Many island families grieving the death of a loved one have the added stress of finding out their family member did not write a will, that the will is invalid, or that no executor was named. When this happens, someone must apply to the court to be appointed administrator of the estate. An administrator has the same duties as an executor. However, unlike an executor, the administrator must post a bond with the court. The court holds this money until the work is complete. As well as the bond, two other people must agree to be held liable if the administrator mishandles the estate. They are called sureties. Once appointed, the administrator receives letters of administration from the court. This document authorizes them to act for the estate. Before working on the estate, it's a good idea to speak to a lawyer to learn the rules and expectations of the court. It's at this point that you collect all assets and any money owed to the estate to be put in a bank account, specifically for the estate. You must also contact Canada Revenue Agency and Service Canada to tell them the date your loved one died. When issuing letters of administration, the court automatically sends a notice to the Royal Gazette of PEI. This announces the person's death and asks creditors to notify the administrator if the estate owes them money. Creditors have 6 months to come forward. Before any gifts can be distributed, you must pay all debts of the deceased person. Debts must be paid in the following order: mortgages and other secured debts, funeral expenses up to $2,500, expenses of administration, some medical and nursing home expenses, and only then other debts on an equal footing. Once the debts of the estate have been paid and the final tax return is filed, you can apply for a clearance certificate from Canada Revenue Agency, confirming the estate has paid all taxes, interest, and penalties owing. After getting the clearance certificate, you can begin giving out bequests and gifts. Make sure you get receipts for anything given to anyone, and take care to keep records of any expenses related to your own work as an administrator. If there is a will, the estate is distributed according to your loved one's wishes. If there is no will, the Probate Act tells you what to do. If the deceased is survived by a spouse and no children, the estate goes to the spouse. If the deceased is survived by a spouse and one child, each gets a half. If the deceased is survived by a spouse and more than one child, the spouse receives 1/3 and the rest is divided equally among the children. If the deceased has no spouse or children, then the estate would go to other relatives, first parents, then siblings, then nieces and nephews, and so on. And finally, if there are no surviving relatives, the estate goes to the government. To be released from the bond, get written consent from all beneficiaries to release you from the bond. The court may also require a full accounting of the estate and other court paperwork. Once everything is approved, the court will issue a decree on passing accounts, which authorizes the cancellation of the bond and releases the sureties. Finally, to be safe, keep all records relating to the estate for 7 years. This can protect you later if questions arise. I hope this brief overview was helpful. There are a lot of details I couldn't cover. Community legal information can help you learn more.